Tell us what's on your radar, Kim.
Well, today the Supreme Court takes on the question of whether or not a woman has the right to an abortion. Though we won't know the decision until the summer when the court issues their opinions, what's happening today in court is what pro-life activists have been dreaming about and pro-choice activists have been dreading for decades. Will Roe v. Wade be overturned? That is the big looming question. And I'm going to break down the case for you so you could completely understand what it's about and what's actually at stake. Now, the case in front of the court today is Dobbs versus Jackson's Women's Health Organization. The case involves a 2018 Mississippi law that outright bans abortion after 15 weeks of gestation, except in very limited circumstances. The case was immediately challenged in the courts, and both the U.S. District Court for the Southern District of Mississippi and the U.S. Court of Appeals for the Fifth Circuit held that the law was unconstitutional under the Supreme Court's precedents in Roe v. Wade and Planned Parenthood versus Casey. Roe v. Wade gave women the fundamental right to an abortion in 1973. About 20 years later, in 1992, Planned Parenthood versus Casey modified the law and gave pro-life activists a slight win. So we're going to go over these two cases briefly so we can understand them and then better understand what is going on and what is at risk or what is being debated with Dobbs. So in 1973, Roe gave women the fundamental right to an abortion so as long as the pregnancy was still in its pre-viability stage. This meant that a woman could not be prohibited from getting an abortion until the third trimester. The state could regulate or even outlaw a woman from seeking an abortion except when medically necessary to preserve the life of the woman, only in those last few months or weeks. The court adopted what they called the Trimester System. Essentially, in the first trimester, a state could not interfere or get involved in any way, shape, or form with a woman's choice. In the second trimester, however, the state could not prohibit a woman from seeking an abortion, but they could regulate it so as long as the regulations were in the interest of the health of the mother. In the third trimester, a state could allow regulations and they could even outlaw abortions except when a mother's life or physical health is at risk. So nearly 20 years later, Planned Parenthood versus Casey modified Roe by doing away with the trimester system and instead implementing what's called an undue burden system. Everything about the third trimester remained the same. A state could allow, regulate, or outlaw abortions except when the mother's life or health is at risk. But during the first two trimesters, the state could begin to implement regulations and requirements like 48-hour waiting periods, counseling sessions, ultrasounds, and whatnot, so as long as the regulations didn't create what they called an undue burden on the woman seeking an abortion. The law did not give states the right to outlaw or restrict abortions, only gave them the right to advocate in certain ways for the woman to maybe change her mind. This ruling was seen as a win for both sides. The pro-life camp viewed it as a win because they could begin to implement laws and regulations that made getting an abortion a little bit more difficult. And the pro-choice camp saw it as a win because the case affirmed a woman's right to an abortion up until viability. The fact that the Supreme Court chose to hear Dobbs is very notable. There were some other cases the Supreme Court could have taken on instead of Dobbs that would have further regulated abortions without outright reversing a woman's right to seek one. The court could have taken up, for example, Arkansas's ban on abortions when the reason is a child is diagnosed with Down syndrome, or the Indiana case of whether or not a minor seeking an abortion needs parental consent. But the court chose Dobbs, a case that asks the court to completely overturn Roe and let the states regulate as they wish even prior to the stage of viability. Or, in the least, it asks the courts to allow states the right to begin banning second trimester abortions. As it is, most states, including the liberal ones like California, New York, and Massachusetts, do not allow women to get what is called late-term or roughly third trimester abortions, except in limited situations, such as the woman's life or health is in danger. This is something we hear a lot about in the abortion debate to make people riled up, but the reality is most states don't allow it as it is. All states have to allow first, and most of the states have to allow second trimester. All states have to allow first and second trimester abortions because of Roe and Planned Parenthood cases, but that's now on the table. And it's not quite fully second trimester, I should say, that it's the cutoff is somewhere between 20 and 28 weeks. It kind of depends on the state and their definitions. But it's possible the court doesn't fully overturn Roe, but instead reduces a woman's right down to the first trimester only. So that would be really severely cutting into Roe. It is also possible the court agrees with the ultimate ask in Dobbs, which is to allow states the right to regulate and ban abortions at any stage in the pregnancy. That would be completely overturning Roe. And the court might do that. The court could decide abortion is an issue not for the courts at all, but for lawmakers. And they could overturn Roe and tell the states to do whatever they want, which is kind of what they do right now when it comes to third trimester. What the courts can't do is ban abortions, which is what some people seem to be afraid of. All they can do is allow states the right to restrict. They've always allowed it in the third trimester, barring certain health situations, but they could open it up for states to regulate second trimester, or in the worst case scenario, all abortions at any stage. So if this were to happen, nothing would change for most people living in most states. Most states wouldn't change their abortion laws at all. 10 states, however, have what are called trigger laws in place, where if the Supreme Court overturns Roe, these states have laws that automatically come into effect banning abortions. So I think in looking at this case that's up there, this is a very significant case. Again, they could have chosen other cases. They chose the one that directly challenges Roe, at least in that second trimester, because Mississippi is wanting to ban abortions after 15 weeks. So this is going to be really interesting to see what the court does. Now, this court is very conservative. Conservative courts tend to think states should have the right to govern themselves completely, and that might be what they end up doing. That is a very scary prospect for a lot of people, especially people living in those 10 states that have those trigger laws that would go into effect that would ban abortions. That would either ban abortions or I think limit them after the first trimester. But, this is, for a lot of people, nothing would change if this happened. For a lot of people, this would. But again, I think I want to stress, because a lot of people are kind of unclear about this, that the Supreme Court would not be banning abortions. They would just be saying, like they do in the third trimester, they don't ban abortions in the third trimester, what is called late term. You could get those in certain states. It's just they open it up for where the states could choose what they want to do. That might be what they do in this case.
All right, and some advocates would love to see the Supreme Court ban abortion. But
some would.
They're not at that place yet. They do have the votes to strike down Roe. The question really is going to be whether or not they do it. And this is a function of 50-year political strategy on the right to use abortion politics to marry the evangelical movement to a business wing of the Republican Party. And now they're kind of like the dog that caught the car. For years, Democrats said, they'll never do it. They're just riling up their base. Well, right. They might do it.
Yeah, they might, because Planned Parenthood versus Casey was actually the same sort of moment where the Supreme Court had a shift. And a lot of people on the pro-life right felt like, wow, okay, this is our moment. We now have these Supreme Court justices who might overturn Roe. And that is why a bunch of states got together and started kind of implementing these laws that resulted in the class action lawsuit of Planned Parenthood versus Casey. And that a lot of conservatives thought, this is our time, we're going to finally do it. And they were shocked that the court actually didn't do that. What the court did was there were some justices that were absolutely for overturning Roe. There were some justices that were absolutely for not. And then there was this middle group where they struck this compromise in their opinion. And that is where we end up with the opinion Planned Parenthood versus Casey. And so they were saying, well, okay, we're not going to overturn Roe, but we'll give you this sort of leeway to create these regulations. And that was kind of the middle ground. We might in this, again, we're at that moment where the conservatives are saying this is our time, the court is conservative. And they might, we might see the same sort of balance that is struck where maybe the court says, okay, you can limit it, but only in the second and third trimester now, not just the third, but we'll open it for the second, but not the first. Or maybe, 15 weeks might be we might see something like this where it limits it even more. And that will be a big drastic change for a lot of people.
And Sonia Sotomayor in the oral arguments today said if the Supreme Court does that, they're going to lose all of their credibility. So how are we going to survive with any political credibility if it appears like our fundamental rulings can be changed just because the politics of a few of the justices switch? And that's an open question.
To put I have kind of moderate views on the policy question of abortion itself, but it is possible to believe, I think I would agree with this, that Roe is not necessarily, even if you wanted or think abortion should be legal, that Roe was not correctly decided, that the Constitution, the Bill of Rights, does not specifically protect this right, and therefore it is up for the states to decide this matter. So you could think abortion should be legal, but that the states are the proper authority to determine what that law should be, just like a whole slew of other laws. And progressives often agree with that. Both sides, right? Right and left wants to say, things they want to be legal. They say, well, that's a fundamental right. Things they don't, well, this local authority, it's up to them. So
Sotomayor addressed that too. She said there are a lot of things that the Constitution doesn't specify, including that the Supreme Court has the last say on everything, which came about because of the Supreme Court ruling in Marbury versus Madison. So not everything is in there.
Yeah. So we'll see what happens. But I agree, Robbie, with that sentiment that this is not actually in the Constitution. So there is I think people should be prepared. There is a high probability, I would say even, that the Supreme Court does whittle this down even more, because we do have conservative justices who read the Constitution as is, and this isn't actually in it. And so they might say, really, and the abortion debate kind of came down to privacy laws. And so I think, anything's up in the air, but we won't know until summer, until they issue their opinion.
Yeah, I agree with you, Kim. I think people should prepare that it's going to get narrowed, if not the precedent undone entirely. But we'll have to see. And we'll have more Rising after this.